Major breaking news out of New Orleans, Louisiana. A huge oral argument took place today in front of the United States Court of Appeals for the Fifth Circuit in a case called Reese versus the Bureau of Alcohol, Tobacco, Firearms, and yes, Explosives as well, BATFE. Major case involving whether or not young adults between the ages of 18 and 21 can acquire firearms from a federal firearms licensee, an FFL. Major argument involving our Second Amendment rights. Stay tuned. Let's talk all about what happened this morning in New Orleans. Hey folks, I'm Mark Smith, host of the Four Box, a diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, argument today, United States Court of Appeals, Fifth Circuit. That is out of Texas and Louisiana, down there in New Orleans, in the case of Reese versus the BATF. This case involves a federal gun control law and a federal gun control regulation saying that 18 to 20-year-olds, that's right, 18 to 20-year-old young adults, despite being allowed to, among other things, vote, are not allowed to acquire from a federal firearms licensee, an FFL, a firearm because they're prevented from doing so. Specifically, the licensed dealers, the FFLs, are not allowed to sell to these young adults. Even though they're American citizens, they're part of we the people, they're allowed to vote, and they have all sorts of other rights. But under federal law, as it stands, can't sell them guns if you're an FFL. Strangely enough, they can buy guns separately away from an FFL under the law, but they can't buy it from an FFL. How weird is that? Now, this is a huge deal for the following reason. The three-judge panel is Judge Edith Jones, a Ronald Reagan appointee, Judge Reese Barksdale, a George H.W. appointee, and Judge Jennifer Elrod, a George W. Bush appointee. Now, I feel highly confident that this three-judge panel is going to rule against the federal government. Mind you that the lower court, the inferior court, the district court judge out of Louisiana ruled in favor of the United States Department of Justice, upholding the law under the Bruin test of text first, burden shifts to the government, and then government has to come forth with historic analog laws to justify the gun control law. In this case, they got to go back to 1791 and show that there were laws that prevented 18 to 20-year-olds from being able to acquire firearms, which you're going to see in 1 second why that's impossible for them to meet that burden if you're the government. So despite losing in the district court, this appeal to the Fifth Circuit, it seems pretty clear to me we're going to win this 2-1 or 3-0 for a couple reasons. First of all, let's begin with the text of the Second Amendment. The right of the people to keep and bear arms shall not be infringed. The right of the people. So the first question that this panel was, I don't want to say struggling with, but was contemplating was whether or not the people include all Americans, including, but not limited to, 18 to 20-year-old American citizens. Well, it's pretty clear the answer is yes. In fact, I think a comment was made by Judge Edith Jones along the lines of, hey, in the Militia Act of 1792, which is the Militia Act of 1792, adopted 1 year after our Second Amendment was ratified in the year of our Lord 1791. If you look at the Militia Act of 1792, adopted by the United States Congress, they say that 18 to 45-year-old men, white men back then, 18 to 45-year-old men had an obligation to bring with them to militia duty their own, I repeat, their very own, privately owned, by themselves guns. Those guns included firearms, muskets or rifles, ammunition, the black powder, the cartridges, the pouches, and so on. So how is it possible that the government can show that in the year of our Lord 1791, 18 to 20-year-old young adults were not part of the people, as in the right of the people to keep and bear arms? They were allowed to acquire firearms when under the Militia Act of 1792, 18 to 20-year-olds were included in a group of Americans that had an obligation to privately acquire, mind you, privately acquire their own weaponry, their own ammunition, their own guns, and then show for militia musters under federal law. If they did not have an obligation, if they could not acquire the guns in the first place, if they did not have their right to acquire them in the first place, how could they get the guns they needed to then in turn show up for militia duty? Because they were always supposed to bring, and this is key for those of you in common use, we talk about in common use for gun ban cases, arms ban cases. The Americans were supposed to bring those guns, those rifles and those muskets and that ammunition and those weaponry systems, whatever it was, that were in common use by Americans, by ordinary Americans for their normal day-to-day lives, and they would bring those ordinary weapons with them to militia musters. That's why in common use by law-abiding by Americans for lawful purposes is the standard that if we meet, we undeniably win, because it was people that owned these guns and then brought them to militia musters. And here, of course, under the Militia Act of 1792, that included undeniably in the federal statute itself individuals that were between the ages of 18, 19, and 20. The exact cohort of Americans that today Merrick Garland and the Department of Justice and the federal statute 18 U.S.C. 922B as in Bob 1, that's 922B as in Bob 1, B1, and 922C1, Cat 1, 922C1 say that federal firearms licensees or FFLs or federal firearms license dealers are prohibited from selling to Americans under the age of 21. And there's similar regulations that go along with this to kind of reaffirm this. Well, it seems pretty clear that we're going to win this case, and you're going to see why this is a big deal in 1 second. The reason why we're going to win this case is, in addition to the fact that 18 and 20-year-olds are clearly part of the people, then the only question, of course, is also, well, guess what? This is a ban on sale or the purchase of these guns, right? Guess what? The word sale, the word purchase, does not appear expressly in the text of the Second Amendment. It says the right of the people to keep, which means to possess, according to the Supreme Court, and the right to bear, which means to carry outside the home, according to the Supreme Court, right? To possess and to keep, to bear, to carry. So the reason why this is significant is I think we're going to win this case 2-1 or 3-0, and who are we going to defeat? We are going to defeat the federal government. A federal statute will be declared unconstitutional, in my view, by the Fifth Circuit Court of Appeals. In the same way the Fifth Circuit Court of Appeals declared unconstitutional 18 U.S.C. 922 G8 in the Rahimi case, which means that Merrick Garland is going to have no choice whatsoever, because it's his duty to defend federal law and for his Solicitor General's office to defend federal law. So when this Fifth Circuit decision comes out in the next 90 to 120 days is my guess, that says that this federal law is unconstitutional, that the federal law that prevents FFLs from selling to 18 to 20-year-olds is unconstitutional, Merrick Garland is going to have to seek certiorari to the U.S. Supreme Court next spring or next summer of 2024, and the U.S. Supreme Court will grant cert in this case. Almost certainly, I would say 99% certain that they will grant cert in this case if Merrick Garland seeks cert, which I think he has no choice to do so. Which means in the year of our Lord 2024 through 2025, that Supreme Court term, this case, I predict, is actually going to be one of the next Supreme Court cases touching on the Second Amendment. And it's a good one for us because I think we're going to win this case, because I don't see how 18 to 20-year-olds are not part of the people, since the U.S. Supreme Court has already said that all American citizens are part of the people. And then that shifts the burden to the government to show that historically 18 to 20-year-olds were not allowed to have guns at the time of the founding in 1791. And that is impossible for the government to meet their burden. Remember, it's the government's burden to meet this burden, right? It's the government's problem. We can just sit here and look out the window. The government, once you shift to the history, the government has to do something. We don't have to. We're like a criminal defendant. We just have to sit there and watch the government put on its case. We technically don't have to do anything. We don't have to put up a defense or anything because the burden's on the government. Likewise, the case is here. And when the government tries to show that in 1791, the founding fathers thought that 18 to 20-year-olds could be banned from carrying guns, they're going to run smack dab into that huge brick wall of the Militia Act of 1792 that says that 18 to 20-year-olds not only had a right to get these firearms and this ammunition, they actually had to privately acquire these things so they could in turn bring it to militia musters under federal law. That's right. So basically, it's going to be game over for the Department of Justice, which is going to be huge for us because it's going to, I think, help us with the definition of who the people are, going to make it less likely that the government can play games with that term. The other thing that's mission critical is it's also going to speak, and I know a lot of you on Twitter are going to be excited about this. It's also going to speak when the Reese versus BATF case goes to the Supreme Court. It's also going to start to robustly talk about ancillary rights. Because again, the text itself says of the Second Amendment, the right of the people to keep and bear arms, right? But it doesn't say buy or sell. However, obviously there are ancillary rights, such as the right to acquire a gun. And as I see it, there's really only three ways, conceptually, you can acquire firearms. One is you buy them, two is you inherit it, and three is you make it, right? That's it. That's the only way. You buy it, you inherit it, or you get it as a gift, or you make it yourself. And I think that this Reese versus ATF case, which the Supreme Court looks to me, if I'm predicting, is going to have to hear this case in 2024, 2025, is going to start to talk about these ancillary rights. And I think we could see in dicta discussions about how ammunition is an ancillary right, acquisition, purchasing, sales, and things like this, and shut down some of this nonsense we're seeing. So I think this case of Reese versus ATF has the potential to be a really powerful victory for the Second Amendment in the year of our Lord, or I should say the Supreme Court's term of 2024 through 2025. Obviously, a lot can happen between now and then, but I don't think this panel is going to rule against the Second Amendment out of the Fifth Circuit. I think Merrick Garland's going to have to seek cert because it's declaring a federal statute unconstitutional in one part of the country while it's constitutional in other parts of the country. It's going to force Merrick Garland's hand as the Attorney General to seek cert. And I think the Supreme Court, when the SG, meaning the Solicitor General's Office of the Department of Justice, seeks cert on a federal statute that's been declared unconstitutional, basically they always accept that case. And I think we saw that with Rahimi, where Merrick Garland, went and rushed out, claiming that Rahimi had to be heard by the Supreme Court because 922G8 was declared unconstitutional by the Fifth Circuit, and the Supreme Court took it up immediately. And I think we'll see the same thing here. The difference is that the Reese versus ATF case is a much more favorable case for our right to keep and bear arms than obviously Rahimi, which we'll be talking a lot more about that case later this week. So, all right, folks, hope you learned a little bit something today. We'll keep our eyes open and on this Reese versus ATF case. And don't forget to subscribe to the Four Boxes Diner, and make sure you follow me on X at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.